The architecture of American democracy rests on the principle of transparency, particularly concerning the forces that shape its foreign policy. The American public and its elected officials have a right to know not only what policies are being advocated, but on whose behalf that advocacy is conducted. It is this fundamental principle that animates the Foreign Agents Registration Act, FARA, a law designed to eliminate the role of foreign interests in the American political arena, enacted to ensure that the U.S. government and its people can evaluate political speech and lobbying efforts with full knowledge of their origins. FARA serves as a critical bulwark against undisclosed foreign influence. I will argue that the American Israel Public Affairs Committee, AIPAC, is one of the most powerful and effective lobbying organizations in the United States, particularly in Washington, where it conducts activities that fall squarely within the statutory definition of a foreign agent, an agent of a foreign principal. And as such, it should be required to register with the Department of Justice under said act. This is not an argument to prohibit AIPAC's activities, but to subject them to the same legal transparency required of other entities that act to advance the interests of foreign governments within the United States. The case rests on a meticulous examination of the law's text, its legislative intent, and a factual analysis of AIPAC's history, structure, and operational methods, which demonstrate a consistent and coordinated effort to advance the policy objectives of the government of the State of Israel. The Foreign Agents Registration Act, codified under 22 United States Code 611-621, is a public disclosure statute that requires individuals and entities engaged in political or advocacy work for foreign entities to register with the Department of Justice. The law does not prohibit any specific activities. Its purpose is to ensure that the United States government and the American people are aware of persons who are acting within this country as agents of foreign principles, so that their activities can be evaluated of their associations. This framework of transparency is the central pillar of the Act. The legal obligations under FARA are triggered when a person or an entity meets the definition of an agent of a foreign principal. This definition is intentionally broad, encompassing a wide range of relationships and activities far beyond formal contractual agreements. A, quote, foreign principal is defined to include a government of a foreign country, a foreign political party, any person or organization outside the United States, or any entity organized under foreign law or with its principal place of business in a foreign country. The government of Israel, its ministries, and its political parties unequivocally meet this definition. The crux of the legal analysis lies in the statutory definition of an, quote, agent of a foreign principal. FARA defines an agent as, quote, any person who acts as an agent, representative, employee, or servant, or any person who acts in any other capacity at the order, request, or under the direction or control of a foreign principal, end quote. The use of the disjunctive or is legally significant. It means that any of these conditions, order, request, direction, or control, is sufficient to establish an agency relationship. This broad phrasing obviates the need for prosecutors to prove a formal command and control hierarchy, such as direct payments from a foreign government or the presence of foreign officials on an organization's board. Indeed, the threshold for triggering FARA registration is remarkably low. A legal analysis and Department of Justice guidance have clarified a mere, quote, request from a foreign entity can be sufficient. a request from a foreign government official to arrange meetings with U.S. officials or to provide advice on how to influence United States policy can trigger the registration requirement, even in the absence of a contract or compensation. This quote-unquote request standard is the legal central hook for analyzing AIPAC's activities. While AIPAC and its defenders frequently argue that the organization is not, quote, controlled by Israel because it is funded by American donors, this argument deflects from the other, less demanding prongs of the FARA test. The operative legal question is not whether the Israeli government controls AIPAC, but whether AIPAC acts at the request of or in the interests of the Israeli government. The evidence presented will demonstrate that AIPAC's activities consistently meet the standard. Once an agency relationship is established, the scope of registrable activities is extensive. An entity becomes a foreign agent if, at the request of a foreign principal, it engages in a number of specified activities within the United States. These include engaging in political activities. This is defined as any activity intended in any way to influence any agent or official of the United States government or any section of the American public with reference to the domestic or foreign policies of the United States of America or the political interests of a foreign government. This covers nearly all forms of lobbying and public advocacy. Acting as a, quote, political consultant, public relations counsel, or publicity agent includes informing or advising a foreign principal about the United States political conditions or disseminating information to the public on behalf of the principal. Representing the interests of a foreign principal applies to representation before any agency or official of the United States government. Soliciting or disbursing fund includes collecting or distributing money or other things of value in the interests of a foreign principal. An organization need only engage in one of these activities at the request of a foreign principal to be legally obligated to register. Upon registration, the agent must publicly disclose its relationship with the foreign principal, its activities, and its finances, and must label any informational materials it disseminates with a conspicuous disclaimer identifying the agent and the principal. This legal framework, with its broad definitions and low threshold for agency, was deliberately designed to cast a wide net, ensuring that all forms of foreign directed influence are brought into the light of public scrutiny.